Oh, goodness. Well,
I don't know who put it in the wrong place. It's page 19, but it comes before, it appears before page 18 instead of after 18.
that was the error.
So,
At least it's been identified.
okay, you may proceed.
Thank you so much. Mr. Bester, we were dealing with the medium-term mandate and its extension before the lunch break. And we had established that this was a mandate that originated in 2008 in order to allow for procurement of coal to occur on a one-to-one basis as opposed to an open tender scenario. And what I want to move to in that context is what sort of protections were then put in place to ensure regularity in the process of this one-on-one contracting? What sort of measures did Eskom develop to ensure that they were getting the best value for money, they were following all the correct procedures prior to procurement?
Chair, I think the medium-term mandate, both the first one and the subsequent extension thereof, went into some detail where it said in order to protect Eskom, it wanted Eskom to procure the coal legally. And so there were various provisions in there that said it wanted to ensure that the companies was in fact properly established. So there would have been a KYC process or FICA process. In other words, you would have to establish the company in fact existed. Those would be the basics. Environmentally compliant. These are all things, in a way, also to protect Eskom's risk. You wouldn't want to contract with a supplier that was not compliant and would subsequently be shut down through something beyond Eskom's control. So it only made sense that we did some form of risk management in order to make sure that the supplier complied with the laws of the country. And then, obviously, pricing is of key consideration. As I said previously, we would at any time be engaging with a number of suppliers, and we had a pretty good database on what we envisaged as being a fair price. So that would be determined in two probably key ways. Well, maybe three. The mandate number one gave clear guidelines as to within which price parameters you were allowed to pay for coal. I think that's probably the most important one. And as long as we could show, and I used to give an update to the board every 6 months on how we were procuring coal against that mandate, noting that it did specifically mention what price. The one other thing that came out in the revision of the mandate is, if I remember correctly, the first mandate gave an overall delivered price, whereas the second mandate tried to specifically split out the cost of the coal and the cost to deliver. So that I guess is one of the key parameters. The other one is we would have a very good understanding, depending on where the reserve was, whether it was an underground mine, whether it's an open cast mine, what the cost of producing coal from that resource should be. That also depended on the coal qualities. It's not an exact science because some of these suppliers would be exporting the coal, and some suppliers would only be supplying Eskom. So if they were exporting the coal and they were making additional margin from the export coal, we would automatically know that we could probably negotiate harder with the supplier. It was our intention that each of our suppliers should be sustainable as well, because it benefits both parties. So we applied a margin, and if without going into confidential information, we applied a band of a fair margin to what we understood their costs to be. We would often try and get our suppliers, if they weren't happy with the negotiations, to convince us of what costs they were actually incurring. However, the third and probably the final one, that we benchmarked each of these suppliers against other suppliers that we were contracting with that were potentially able to supply us. So at any one time, as I said, we might have had a half a dozen to a dozen suppliers we were negotiating with for various sources. So we could also look at our supply plan. For example, the one in question, the Fontaine contract, it's had the potentially to go to Kendall. It's an obvious one because the specification is quite low, but we didn't need coal for Kendall. So we would have required it to supply coal consistent with the Mayuba specification. So we would look at what other potential supplies we had for Mayuba. And in that way, had we had better alternatives, had we had cheaper options, yes, then the rule would always be going to go to the cheaper option.
Could I ask you to go in Exhibit U4 to File 4? Right at the end of the file, you'll see a page 961. That is a document entitled in handwriting at the top, Tegeta Brakfontein Colliery.
Correct.
And what it appears to be is a checklist of various aspects of the coal supply agreement that are required to be satisfied in relation to the contract. You'll see the first relevant line is commercial and financial documents. The next is supplier development and localization. The third is environmental and legal documents. Fourth is technical documents. The fifth is health and safety requirements. And the sixth is logistics. Is that a checklist you're familiar with?
Yes, and that is almost trying to replicate what was the recommendation in that medium-term mandate.
Indeed. So this is what you're checking against to ensure regularity in the procurement process.
Correct.
Is that correct?
Correct.
Right. And that checklist envisages, amongst other things, that there would be technical compliance from the sole source in relation to meeting the coal quality specifications, as well as a financial assessment having been done of the supplier. Is that correct?
That is correct, but the financial assessment, and I think it may come out later specifically, it doesn't refer to the assessment, it refers to the financial statements being collected.
Correct.
In hindsight, that would probably have been a better one to have added to that. However, this was probably drafted in relation to the medium-term mandate. But the financial assessment that you referred to is clearly spelled out in the procurement policy.
Indeed. And there'd be no utility to receiving 3 years of financial statements if you weren't going to analyze them, would it?
Yes, except the one area, yes, would be to establish whether the company had actually been operating, but the financial assessment should tell you that.
Thank you. I'd now like to go into your statement, Mr. Bester, with that background in place. And if we could begin at page 7 of file 3 of Exhibit U4.
Through you, Chair, should I page to that or can I refer to my copy?
I think it will be convenient.
Preferably use the file.
Sorry, which file?
So it's file 3.
All on the same page and same file.
I've got
U4, Exhibit U4, file 3.
Correct, Chair.
And you're on page 7.
On page 7, exactly. And I pick it up at what is paragraph 13 of your statement, which appears on that page, because it's here that you begin to talk about the approaches that had been received by Eskom from Tegeta, albeit that you begin talking about the year 2011, where, as I understand from the rest of your statement, the approaches weren't in the guise of Tegeta per se, but its predecessors. Can you please talk to the Chair about those approaches, when they commenced, And what coal supply was the subject matter of those engagements?
Chair, I need to maybe, Ms. Hoffman can help me with if I get the name wrong, but we were originally approached for supply from another source other than Fontaine, but from the same supplier,
Yes.
is my understanding. It was Fontaine or something.
Fontaine
Fontaine.
Colliery. You'll see that in paragraph 14 on that page, in the
Correct.
second line.
Thank you. So my understanding is that Fontaine was offered to us first, and I could pick up from records that the first time it was offered would probably have predated November of 2011. That is because, as I said, we ran a database, and the first time I did a search for Fontaine, the first time I picked them up was a reference to November. They may have approached I'm not sure exactly where the approach came from. It could have been one of my team members. They would have noted it down in that supplier database.
You had concerns about Fontaine Colliery, did you not?
So the first thing that was done, there was an environmental assessment done on that site. So representatives from the environmental department would have gone to site, and they wrote a report. It's not clear to who they wrote it, potentially to the divisional executive, my boss at the time, Ms. Kiran Maharaj. So they probably, I'm familiar with the report now. They said to her that there were serious environmental transgressions. If I recall correctly, there was a wetland that they appear to have mined through and a river diversion. And our expectation was that if the transgressions had been to that extent, then it would be in Eskom's best interest not to even consider contracting from them. What we also did later on, and it was, I can't remember if it was specifically because of that, we did procure an independent legal opinion. I'm not sure if we'll go to that later, or if I should describe it now.
You can deal with it now.
We did something we don't normally do, because we had an idea as to who the potential owners and beneficiary shareholders of this contract was at the time. We already had a suspicion that it was linked to the Gupta owners, although, the Gupta family. And because we wanted to be very careful in how we responded to that, we sought a legal opinion from We Envisage, and we worded it carefully in order to protect our own interests as well. We wrote to them and engaged with them, and we said to We Envisage, we would like to contract from this source, but please advise us what the risk is if we should contract from them. We did subsequently get a report from them. It's rather voluminous, and it does talk about the environmental provisions, etc., but it does conclude that Eskom would probably be taking on some risk, although that risk does ultimately sit with the miner and the transgression with the mining company. I'm not referring to it now. I think we were comfortable that it was clear that it was their opinion that we should not contract with Fontaine. I don't recall that it specifically talks about Fontaine.
No, it doesn't.
Apologize.
It refers to Fontaine, but we can conclude the aspect on Fontaine. Why was there a sense that you needed to take care if there was an association with the Gupta family in relation to this mine?
Yeah, we already we were already under pressure. The request to engage from them. My boss at the time, Kiran Maharaj, may have known about this. Did not just come from a normal application. It may have come from above, that she was weary about this. I remember at the time as well, we even had to go to, it's not in my affidavit, apologies, but this is some of the things that have come to be subsequently. I recall that I went to, with Mrs. Kiran Maharaj, I went to Mr. Brian Damas's house. I think he was ill at the time, and we had to give him an answer why we weren't procuring while we had no interest in pursuing this contract. I went there with the head of environmental.
To whom did you go?
we went to Mr. Brian Damas, he was then the CEO of Eskom. We went to his house to explain, to give him comfort that we were acting correctly.
So that's insofar as Fontaine is concerned. And Chair, just for your reference, the Webb-Wenzel opinion is at page 38 of that file. It's one of the annexures to Mr. Bester's affidavit, and as Mr. Bester has indicated in his evidence, it ultimately concludes that there would be risks associated with contracting for the Fontaine coal source.
Okay.
So if we can return to Fontaine and the approaches in relation to it, because it was slightly different to Fontaine, wasn't it?
Correct.
And from whom did the approaches in relation to the Fontaine coal source initially come? You can, for your reference, refer to page 7 at paragraph 13. In the middle of that paragraph, you say Tegeta wasn't the initial name of the entity used. They used the names Goldridge, Arctos, and Edwala Crypts. Is that correct?
Correct. If I'm looking at paragraph... Sorry, I haven't found that. I was looking at the previous reference. There was also a reference earlier, I think, in paragraph 13. But I apologize. Which paragraph?
Well, in paragraph 13, on
Yes.
page 7, you'll see the middle of the way down of that paragraph, in the last
Yes, I have it now.
section of the line, you record there that Tegeta wasn't the initial name of the entity used. They used the names of Goldridge, Arctos, and Edwala Crypts.
Yes.
And two different companies and sets of frontmen were used to offer Eskom coal from their Fontaine and Brakfontein collieries.
Yes.
And what happened with the approach in relation to Brakfontein?
Look, I have it in my, without specifically referring to an incident there, my recollection is that because Brakfontein didn't have a water license, we did not engage with them any further.
And this is in about 2012, is that right?
It probably was, yes. I think very shortly after Fontaine, we closed the Fontaine matter. Another supplier, potential supplier, came on board. We did initially struggle to figure out who was behind the offers. They seem to have come from two different companies, from two different representatives.
And then you mentioned the reference to the water use license. If you go over the page to page 8, and in the bottom paragraph on that page, paragraph 16, the first sentence there says, Tegeta's environmental issues and lack of water use license was eventually sorted out by the time the Brakfontein supply contract was signed. Can you please tell the Chair about the developments in relation to that water use license? When eventually was Brakfontein granted a water use license?
I think it is in the file, but I recall it quite well. It was the 22nd of December 2014, and it's pretty much after that that the pressure to contract with them really started in earnest again, and probably at the start of January when we returned from leave.
Okay, let's go to the water use license. It's at page 54 of that file. It's an annexure to your statement. And as you have reflected already, the date of issue was the 22nd of December 2014. In your statement, you indicate that you were surprised by that date. Why is that?
I mentioned it to a colleague, and I was surprised that something as important as that would be signed off when most of us were on holiday. So I was suspicious of that. And my colleague at the time warned me from not overreaching and raising suspicion on that, noting to me that for my own benefit, it's not wise to question that. Let the appropriate people question that. I mean, clearly I might have been, I would have struggled to justify properly why I was suspicious of that. I mean, it's not to say that the relevant person didn't sign off appropriately.
At this stage of your affidavit, Mr. Bester, the impression that one gets, and I want to put this to you so you can correct me if you regard my impression as wrong, is that you were reluctant to contract with Tegeta, first in relation to Fontaine and then in relation to Fontaine. Is that a fair reading of your affidavit?
I was reluctant, and I think at that time already we had, there were some technical tests done, and it was likely that the coal would be marginal as a supplier.
This is referring to Fontaine in particular?
To Fontaine in particular.
And as a supplier to Majuba?
As a supplier, yes, specifically I think at that stage we hadn't decided where to take the coal. I think the initial test, but I'm going on recollection here, the coal could have gone to Kendall and to Krill, some of the Krill units that run on a lower specification, but we didn't have a requirement for that. So in order to meet the power stations that have a higher quality requirement, it would have been marginal.
You also refer in your affidavit to pressure being exerted at this time. You've already told us about having to go and report to Mr. Damas about why you were justified in not contracting in relation to Fontaine. But your affidavit also talks about an event in March 2014 when you were summoned with your colleagues to the auditorium at Eskom. If I could just take you there in your affidavit, it's at page 10. And it's paragraph 21 on that page. Can you please tell the chair about that event in March of 2014?
Chair, it was a very surprising turn of events. At the time, I was acting divisional executive. My boss, or the person I reported to, Mrs. Kiran Maharaj, who was usually the divisional executive, she had been seconded to the cost-saving initiative, and she'd been seconded there for probably the best part of 9 months. So I was initially asked to act in her position, and that, to my recollection, came to an end at the end of the financial year. That's pretty much when Mrs. Maharaj's work was also wrapping up. So what I do recall, and I think I try to recall the date specifically, but I remember that Mrs. Maharaj came to that specific meeting to support me. I'm not sure how she was notified of that, and it's my recollection that I think it was a day or two before she resumed her role as the permanent divisional executive. What was surprising to me is to be addressed, for me to call at the time, since I was the acting divisional executive, I was required to bring my entire team together. Obviously, as you heard this morning from Gert Opperman, he's an operational manager, so he would have been situated in Witbank. And the short notice, he probably wouldn't have made the meeting. So we have several people across Mpumalanga, but all in all, there's 143 people at the time that would have worked for Primary Energy. We were told we all had to be there, all of us that could be there. And the chairman at the time, Mr. Totsi, addressed us, and he complained about two things specifically. That we were frustrating the transporters and we were putting Eskom at risk, and that we were frustrating emerging miners. He didn't mention any specifics. He didn't give us an opportunity to reply. As I said, I was glad that that Mrs. Maharaj was there. She indicated to me that I don't need to respond to that, and she took it upon herself to respond to that. She told me that, well, as I've indicated, I'm not going to read to it now because I recall it in any case by memory, is that she indicated to the chairman that she would do her best and that Primary Energy would pull up their socks. As we walked out of that meeting, Mrs. Maharaj told me that at the moment there was a lot of toxicity amongst the executive team, and that we all had to be very careful.
At paragraph 21 on that page, you also talk about an interaction you had with Suzanne Daniels. Can you please tell the chair about that?
Before you do so, Mr. Bester, what did you understand Ms. Maharaj's statement that among the executives there was a lot of toxicity?
Look, from Mrs. Maharaj, it was not surprising. Having worked for her, I learned to know her as a boss that was very particular, or I can't think of the right word here. It'll come to me. That's very principled, and that I'm not sure how long her career was at Eskom, but it was almost her first. She had worked at one other employer very shortly, and she doesn't have children, and she dedicated almost every waking hour she had to Eskom. I haven't encountered people as dedicated, and she lived and breathed and Eskom almost day and night, and she expected the rest of us to as well. She was a very tough lady to work for, and we respected her for that. So she also, because of that, I suspect over the years had made many enemies as well, because she wouldn't turn a blind eye to wrongdoing.
So, what did she mean was happening at executive level?
She didn't elaborate on that, but I know that she had made enemies on her way up to that senior position.
Or you say you know that she had made enemies at
Yes.
that level herself because of how principled she was.
Correct.
Okay. Did you have your own reading of the situation at executive level, and are able to tell me what it was in your own assessment? Anything connected with what she was trying to convey to you?
There were many matters, and as I reflect maybe later, even at the time, one of them was specifically the coal transporters issue. And I know that one of and I had personal discussions with Mrs. Maharaj, and I think there were, I'm not exactly, I think it was maybe that we were trying to push through a cost saving of around 15%. On the rates that we were being charged by under that transport contract. And I think I've subsequently read that maybe the rate that we were trying to, the saving that we were trying to push through was between 13 and 15%. And I had long discussions with Mrs. Maharaj on that, and I had actually, on a personal level, encouraged her to rather make it 5% per annum over the next 3 years, not to push for 15%. But Mrs. Maharaj was very much driven, and I think that's one good example of where she didn't see eye to eye with the rest of the executive, and I think I've seen it on another record that, and I'm led to believe that's what was her undoing eventually. So it was issues like that where she was very principled and very determined to achieve certain things, and she was eventually called in that she was, I think it appears, and I don't have this firsthand, that the board had actually told her to back down of that demand, and she refused to, and she was eventually asked to leave because of that.
Would it be quite close to a correct description of what she may have meant to say, or what you understood the position to be at executive level, which she was trying to describe to you, to say there were tensions at executive level, maybe between those who wanted the right things to be done and those who might have wanted the wrong things to be done?
Chair, that is my impression. That was the kind of pressure that she was under. Okay. That she didn't get the support from her,
yes,
maybe direct superiors at the time.
Okay, thank you.
Chair, just to relate Mr. Bester's evidence at this point to the evidence that we've heard from Mr. Nagar. Mr. Nagar also made reference in the course of his evidence to things being ugly at Eskom, and it was in that context that he referred specifically to Ms. Maharaj and the stand that she took in relation to the transporters. So this is a further confirmation of that element within Eskom.
Thank you.
We were dealing with what Suzanne Daniels said to you after this meeting in the auditorium, and you record that at the second half of the paragraph 21 on page 10. Can you please tell the Chair about what Ms. Suzanne Daniels told you was the source of the unhappiness that was expressed at that meeting?
She couldn't, Chair, Suzanne Daniels, I don't think she could be specific because, but she operated more closely to executive, and she said that files she had, that she had been dealing with, that the chairman may have been concerned about, led her to believe that is actually what he was speaking to. At the time, I had a good rapport with Ms. Daniels, and I expect that she would have given me that information for my own good.
And if we go higher on that page to paragraph 20, you talk in the middle of that paragraph about Mr. Mboweni and the regularity of his engagements with you, particularly over the course of late 2014 and early 2015 in relation to the Brockfontein contract. Can you please explain to the Chair what the nature of that engagement was?
Through the Chair, I'm not sure if you're referring to how I set it out or my specific engagement with Mr. Mboweni.
No, what I'm talking about is, let's go to the sentence in the middle of paragraph 20. You say there, from time to time, Mr. Mboweni would call me, even on the weekend, to check on progress with sampling and site visits. Although I knew who was probably behind the calls, I told him that he shouldn't entertain suppliers and that he should let the team deal with matters. What does that relate to?
Yes, I'd been aware that, I mean, obviously that he'd only recently started in that position, and so I think our relationship was a little bit different at the start, and I knew Mr. Mboweni wasn't all that well health-wise, and I think I was really trying to give him some advice at that stage, that he shouldn't, that these kind of instructions shouldn't come from the top, that he should let the team and those responsible for their work do the work without being pressurized and without feeling the pressure. It's very important in the environment that we were working in, because Eskom is very hierarchical, and I realized that the day I was made acting divisional executive, I got a lot more out of people than I did previously. There was a lot of respect for that hierarchical culture, and if instructions come from the top, people do their best to try and deliver on that. But I did warn him. Maybe I wasn't thinking about that as much at the time, but in hindsight, I did warn him that he needed to let the process run itself out. And he wanted to follow up on sampling. I myself didn't even interact with the technical team except the head of the technical team. So I wouldn't even have had the phone numbers of the people to phone to sort that out. And I said he must let the people responsible to do that kind of work, to do it appropriately and when it was scheduled. Because I actually did make, after the phone call, I did make a couple of inquiries. And my direct report, who was responsible for that specific contract, did tell me that it was actually the supplier, the sample wasn't ready on the Friday when it should have been. You know, that wastes his time and wastes my time, but it also puts pressure on people, maybe to cut corners and maybe to do things you know, under pressure. And I preferred, that's not the way I managed.
Thank you. So can I understand from your description of that interaction that your sense from Mr. Mboweni was that people above him in the hierarchy were putting pressure on him to follow up about the Brockfontein contract?
Correct. I'm not sure if it was that specific instance I was referring to, but there was another mine that he also got pressure on, which is unrelated.
Which one was that?
I mean, off the top of my head, I know it was a supply from Westcol, and I think one of the owners is well connected and made a few phone calls, and the pressure came from the top. And I really just wanted Mr. Mbuweni to be aware that he should try not to tolerate that.
Thank you. I'd now like to get into the detail of the actual negotiations between Tegeta and Eskom. And this will track from the latter part of 2014 through to the actual conclusion of the agreement in March 2015. As I have it, the first written record of an offer from Tegeta, you'll find at page 9.1 of the file in front of you. It's an annexure to your affidavit, and it's a letter of the 23rd of September 2014. Just in terms of the persons identified on this letter, it is addressed to a Ms. Ayanda Nshanga. Who is she?
So she was one of my direct reports. So I had about 24, 25 people working for me, and I split them into 3 different teams. So there was a senior manager who was responsible for each one of those teams. Ms. Ayanda Nshanga, I had specifically tasked with assisting with the transformation. She had a lot of experience previously in some of her previous work with transformation contracting. So I had teams specifically looking at our long-term contracts, and I had another gentleman looking after some of our existing medium-term contracts, and then I specifically wanted Ms. Nshanga later in Teta to specifically focus on driving our emerging black owner strategy. So this would have fallen under that, which is why she was dealing with this one specifically.
And just to be clear on the names, Ms. Ayanda Nshanga is the same person as Ms. Ayanda Nteta, whose name we will see in the course of the rest of the documents we go through. Is that correct?
Correct. During her employee, I think she went back to her maiden name.
Thank you. So if we look at this offer that is reflected on the letter dated the 23rd of September 2014, I'd just like to highlight a few aspects of it. Was this the first written offer you received from Tegeta in relation to Bloemfontein?
It's the only one that I have reference to, but as I said, there were previous offers from different companies. I wouldn't have dealt or filed each of these myself. There may have been others. I am aware, and as I mentioned in my affidavit, that I think the first price that was offered was R17.50. Whether that was on email or whether that was verbal, I don't recollect. Okay,
because this letter refers to an offer price of R17 per Gigajoule. I think the MJ is an error in line 4 of that letter.
Yeah.
And just to be clear, what seam were they offering?
Yes. That is, it's very good to point that out at this stage. They were offering the 4 lower seam. I would have to refer to to the technical reports, but it may have been that the geologist or one of the technical members had already probably engaged with them, and they probably knew that it was only the 4 lower seam that was suitable.
Right. So the offer begins with the lower seam, which we've understood from previous evidence is of a higher quality than the upper seam. And there was a particular quantity offered. Can you take us through that?
Yes. Interestingly, I'm just looking at that now. It doesn't say over what period, though.
I'm aware of that.
So it would probably have, one would think, judging by the volume, that it would be referring to a monthly volume.
Yes.
Anything smaller than that, we would probably not engage if it was an annual quantity.
And the monthly minimum, as I have it, is 40,000 million tons, and the monthly maximum was 70,000 million tons. Is that correct?
No, sorry, not. In this instance, I would think that they were referring to a metric ton.
Sorry, of course,
Yeah.
yes.
No
Million
problem.
would have taken us into serious coal delivery.
Then this
issues.
contract would have had to go to board.
Yes, indeed. And then the rate was 17 rand, is that correct?
Correct. And that, as you correctly point, that should have been in reference to 17 rand per gigajoule.
I'm sorry, Ms. Hofmeyer. Are you still at page 91?
Yes, indeed.
I'm looking for 17 rand. Can't I see it on my one?
It's right at the bottom of the table.
Oh, right at the bottom,
Under
number
point
4. Yeah, okay.
You'll see their rate offered. It really is an
Yes.
error. It should be per
Yeah,
GJ,
yes.
gigajoule, and that is the 17 rand.
Also, that M should be G.
A G, correct.
Okay, thank you. Thank you.
Then just to orientate us, this is September 2014. You've already indicated in your evidence that on the 22nd of December 2014, Tegeta receives a water use license for the Brakfontein Colliery. And then you refer in your statement to a meeting that was held on the 30th of January. I'd like to take you there. That is at paragraph 26 of your statement, which you'll find at page 12.
Paragraph 27, yes, I have that in front of me.
Indeed. And let's, with reference to the actual note that was prepared after that meeting, just go to it. That you'll find at page 9.3. It's the next annexure to the letter we were looking at.
Yes, I have that.
Now, can you please take the chair through what happened at that meeting? What position you took in relation to the offer that had been received, and where the discussions ultimately ended up?
Chair, may I first give some context? It is unusual for me to have attended this meeting without seemingly to try and overstate my role there. I had teams who negotiated these in detail, and when they did get stuck, and obviously when my direct reports required my assistance, they would ask me to give that. In this case, I was instructed to intervene by Mr. Vusi Mboweni. And then, yeah, so the other interesting thing is that our negotiations would happen within the primary energy division part of the building. If you're familiar with Megawatt Park, you'll know that it's quite a big site. Primary energy had a separate wing. It was really, to an extent, to protect confidentiality. So it wasn't a normal walkthrough. These negotiations happened at the executive suite level. There was the two things that were unusual here. I was instructed by my boss. He shouldn't have even have known that we had problems there. And the negotiations, it's abnormal at my level to have discussions in the executive suite. So I was asked to intervene. So I knew this meeting was coming up, and I knew the stakes were quite high. So I didn't even discuss my strategy. I played a few scenarios over in my mind. I'm sorry, I'm not referring to this. I'm trying to recollect as it happened. I knew, as I mentioned earlier, I knew the stakes were quite high, and Mr. Mboweni had actually called me in, and I'm not sure if I mentioned this somewhere, but I do mention the 15 rand a gigajoule. He had told me don't agree to anything higher than 15 rand a gigajoule, which is interesting. He did, to his credit, he said don't agree to anything higher than that. I didn't really respond to that, and I think it was later on in that day or the next day I met with him. And I had run a few scenarios over in my head without engaging with my direct report or anybody else on this. I figured I would put a price to them which which myself as a general manager of fuel sourcing could be comfortable with in terms of the other suppliers we had going to Majuba power station. By that time, I'd already decided that if we were going to buy it for anywhere in Eskom, the best option for us would be to take it to Majuba. So I walked in there. I made some brief introductions, and I discussed the safety procedure. And then I just jumped into it. I didn't really, I really wasn't interested in pleasantries. And I said to them, I may have even have used the words, we all know what the stakes are here. I'm prepared to offer you 12 Rand 50. And I showed him a graph, and I showed him if we were to offer you 17 Rand a gigajoule, it would, and I think I may have used the words, it's going to stand out like a sore thumb. And we all know, and it's not all minuted because I had to be careful not to minute specifics like that. We all know it's going to, I obviously controlled the minute, that it's going to stand out like a sore thumb, and we both know that this contract will be scrutinized. And then people will ask questions about it. So I said, I'm prepared to ask you 12 Rand 50. It reflects in the minutes that they walked out, but they didn't even respond. They got up and they walked out. I must say I wasn't surprised, but I was very nervous. I thought I had maybe overplayed my hand. And I went back to my office. About half an hour later, Ayanda came to my office, and she said there'd been a lot of unhappiness. A lot of people had been screaming at each other at the executive suite. By that time, I'm not sure where in my affidavit I mentioned that. I was already uncomfortable by the fact that Ms. Nteta, or Nchanga at this stage, was being called to Mr. Koko's office and Mr. Mbuweni's office. I know that she was called. She used to tell me that she's been called to the executive suite again. She was never specific, and I never pushed her. And I think I say that in my affidavit. I can't say for a fact. It may even have been the chairman's office. I wouldn't know. I never asked her for specifics. That she came to call me, and I said that, and she told me that they were prepared to make a counteroffer. I went back, and they counted at 13 Rand 50. I had expected and had run that. It was at the top end, but if it was to be taken on rail, it would not be, it would almost match the most expensive contract. It wouldn't quite be the most expensive. I was clever enough not to show them the delivered cost. If I'd shown them the delivered cost, they wouldn't have stood out as far. So I only showed them the actual cost for the coal. They didn't actually even, normally when you engage with Supplier, they have every single iteration and answer ready for you. I also suspect that maybe the team that engaged with me hadn't prepared themselves very well. So when they agreed to that, they never specified that it would be, later on they tried to claw back some of the positions by referring to 4 upper and 4 lower. It may come out in some of the later correspondence. But they agreed to that. They said 13 Rand 50. And I wasn't going to assist them.
Didn't they counter offer? You had to agree to it.
I beg your pardon. They did counter offer, yes.
Yeah, you were the one who was supposed to say whether you agreed or you didn't agree to that, isn't it?
I agreed to that, yes.
Yeah.
But what we may have been remiss of, and it's maybe them not having experience or maybe having thought through it, when they replied and accepted the 13 Rand 50, when they offered the 13 Rand 50, they never made it specific that it was for the 4 upper and the 4 lower. So if you recall that the offer letter they had made was specifically a high price for the 4 lower, which would be expected. You would want a higher price for the better quality seam. If you were to blend the two, then I would expect that the price would be lower. I offered them a lower price, but in my mind it was for the 4 lower seam. When they replied and they responded with a 13 Rand 50, they were not specific, and the assumption was that it was for the 4 lower seam that they had responded. I don't think we minuted that.
No, you did, and I don't think it's entirely accurate. If you go to page 94,
okay.
The third bullet from the bottom in the technical discussion, says that Together are proposing to supply 65 kilotons a month of the blended product, seam 4 upper and seam form lower. So it seems at that meeting that a blended product was already on the table, and that if you go to the second bullet on that page, what I understand to be reflected there is that RN, who is Ravinda Nath, as you see the attendees on the front page, who was the Together representative, came back with a price offer of R13.50 per gigajoule for a 5-year contract of approximately 65 kilotons per month from the Brakfontein resource. Is that accurate?
Yes, and you're correct. Yes, the latter part of the discussion does refer to a blend. So that may have been the understanding then that we left with.
Thank you. And the other thing that is fairly important on this record of the meeting is the second last bullet. That bullet records that the proposed start date would be the 1st of April 2015, subject to a successful combustion test. Why was that included?
It would be, specifically since it follows on the next one, I would imagine it's because I think in August 2014 there had been a burn test already, but there had not been a burn test that successfully accepted a blend of the two seams.
Correct. So we're now in at the end of January 2015. You don't yet have a successful combustion test for this source, but there's a meeting between Together and Eskom at which they start at 17 Rand. You counter at 12 Rand 50. They walk out. There's a screaming match. They return and they offer you 13 Rand 50, and you accept that. Is that a fair summary?
Correct.
And you accept it for a 5-year contract. Is that correct?
Well, that's all that was offered at the time.
Right.
Yeah, is my understanding.
And it is in relation to a blended product that had not yet been identified as suitable. So
Yes.
that had to be subject to a combustion test. Is that correct?
Correct. And then there was, I'm not sure if it refers to that, there was some discussion on Brakfontein extension already that came in, or additional volumes.
Yes. If you go to the third bullet on that page 94, what is also recorded there is that Eskom agreed to accept the price, provided that Eskom has the first right of refusal for additional coal resources at Brakfontein extension. Furthermore, the coal must meet the technical and combustion requirements of Majuba Power Station. Is that consistent with your recollection?
Correct.
Thank you. This was followed by another letter from Together. And for that purpose, we need to go to file 4. You refer to this letter in your affidavit, but did not attach it. And so we managed to find a copy of it. If you go in file 4 to page 786.2, you'll find that letter.
What's the page again?
786.2.
786.2.
Indeed, Chair.
Okay, thank you.
So I'd like to highlight some aspects of this letter. This is a letter written by Together to yourself, is that correct?
Correct.
And it's dated the 3rd of February, which is a few days after the meeting on the 30th of January. It refers to a letter of the 30th of January. Can't say that we've seen that, but you've confirmed that those minutes reflect accurately what was discussed at that meeting. Is that correct?
Yes, and it's likely that I would have captured it in a letter. Yeah, sorry, Chair. Yeah, I think what I tried, it's a pity I don't have the letter, but I recall it specifically. It dealt with that, with the volume and the price, and then that item. But it reflects accurately the minutes that I said that we wanted the right to be able to call for, the first right of refusal to call for coal from Fontaine, not to have to take it.
Right, so let's see what happens on the 3rd of February. The 3rd of February, the offer seems to be increasing in terms of volume, at least from a point in the contract. So if you see the first bullet point, so I understand it, what Tegeta is saying there is they're happy to supply 65,000 tons per month from 1 April 2015, but they'd like to supply up to 100,000 tons per month from the 1st of October 2015, because they record that the Fontaine colliery would be operational by then. Do you see that?
I do.
And
well, it doesn't say as the extension of Fontaine colliery would be operational by then. I think you said Fontaine colliery, but I'm under the impression here this is where they mean the extension.
Indeed. Apologies, Chair. If I read it incorrectly, what they clearly are seeking to convey, and correct me if I'm wrong, Mr. Best, is that from 1 October, the extension of the Fontaine colliery would be operational, and so they want to supply increasing volumes. Is that correct?
Yes.
And they would keep it at the same price of R13.50. Is that accurate?
Correct.
Let's deal with the second bullet point in relation to black ownership. What was the issue around black ownership?
I can speak in general about the black ownership targets, but trying to pick up a specific issue, I'm not sure what they actually meant by we seek favorable consideration for a 10-year supply agreement as a reserve, support the supply of volumes required for this period. I'm not sure what they actually were asking for there.
Well, hang on, we haven't got to that yet. The second bullet on the page is dealing with black ownership. It says, in our numerous interactions, we've requested Eskom to allow us to increase our black ownership to 50% plus 1 share in a phased manner over a period of 3 years. Why were they dealing with this aspect in the letter?
I think the minutes, either this one or another set of minutes, would have referred to the fact that we had a target to transform Eskom's coal procurement. We had a target to try and achieve, I think it was either 63 or 65% of our coal procurement to coming from black-owned suppliers by 2018. So it's not, so this would have, so the team, Ms. Nteta and her team would have conveyed that desire or requirement to them.
And then the third paragraph is the one that you'd gone to, where they say, due to our commitment to the increased ownership coupled with Eskom's and the DPE's commitment to support the sustainable growth of majority-owned junior miners, we seek your favorable consideration for a 10-year supply agreement as our reserves support the supply of volumes required for this period. What did you understand that to mean?
As I said, even reading it now, I don't see any specific concession required there. They were offering additional coal, and they were saying we will endeavour to support your black ownership targets, etc. So look at this favourably. I mean, it's not. It wouldn't surprise me that a supplier would write along those veins.
But just in reference to the meeting you'd had a few days previous, they were talking about 5 years, speaking about, one would assume, the same source. And a matter of days later, they're talking about 10 years. Was that not something you wanted to interrogate further?
It's not surprising though, but one would probably want to know why all of a sudden they want to move from 5 to 10 years. But I can't say I specifically applied my mind to why they would want to go from 5 years to 10 years. It stands to reason that they would want to have a long-term contract. And it makes sense if you have the reserves to rather offer it for 10 years than 5 years. So, I mean, in hindsight, you may say, yes, they got the foot in the door and they wanted to open the door properly. But it's our role to buy coal, and if there's a requirement, there shouldn't really be an issue with that.
Mr. Besser, your response to this was on the 12th of February.
Right.
If you go back to file 3 at page 98, you'll find it there.
What page at?
98, Chair. I'm interested in the duration of the contract because on the 30th of January they're offering 5 years. On the 3rd of February they're offering 10 years. But your response on the 12th of February seems to, and again you must correct me if my reading of this letter is inaccurate, but it seems to me to want to keep Eskom committed to the 5 years, but not yet commit Eskom to the second 5 years, and rather have an option in relation to the second 5 years. And I take that from the second paragraph on this page, because what is recorded there is that Eskom has agreed to take 65,000 tonnes from Braamfontein Colliery. Further, Together will offer to Eskom at the same commercial terms as set out herein from their Braamfontein Extension Colliery, and Eskom has the option to enter into an offtake agreement for the additional coal from Braamfontein Extension Colliery. Is that a fair reading of what you were conveying?
Yes, it may be from my intention initially when we met with them on the 30th that they had mentioned to us that they had additional coal, and I wanted that to be at Eskom's election, not at their behest or demand.
Right, and that is confirmed over the page at page 99, because under point 5 on page 99, where you refer to the duration of the contract, you say an initial 5-year duration with an option to extend for an additional 5 years for a total duration up to 10 years for a maximum tonnage of 12 million tonnes. Is that correct?
That's correct.
You also added a number of conditions to this letter. Well, before we do that, if we could just go back to page 98. You'll have seen in the evidence this morning with Mr. Opperman, I placed some reference on the 2 asterisks that found their way into the coal supply agreement under the coal quality specifications. As I have it, it actually makes its first appearance in this letter of yours on the 12th of February. Because under the coal specification table that you've reflected there, you've also included that double asterisk. What I'd like to ask you is your comment on the debate that Mr. Opperman had with the chair about the thinking behind that asterisk, which talks about full combustion tests will be conducted on all proposed coal prior to delivery and acceptance by Eskom. Did you follow that debate between the chair and Mr. Opperman?
I did, but it might help maybe just repeating my understanding. So it would not be the intention of this clause to do a burn test on every stockpile that was created by the supplier. It would, in this context, it would be fair to assume that that refers, or that the intention here was to refer to any coal resource being offered to Eskom to first having to pass the burn test, whether that be a blend or whether that be from Braamfontein Extension. This was to cover Eskom, that it was in fact compliant with a proper burn test being done.
So it was intended for coal being proposed that came from a different mine than the one from which the coal that was already being supplied to Eskom was coming from. In other words,
yes,
it was intended to apply to coal coming from a mining operation that had not yet supplied Eskom with coal.
Correct. So these letters wouldn't only be drafted by myself, and if I reflect on this, it looks like it's exactly a similar version. I'm sure Ms. Hofmeyer can assist me with that, but it seems a very similar or the same version as what was finally included in the original coal supply agreement. So in drafting of these letters, we would have been assisted by legal, but legal wouldn't have drafted that technical paragraph, and legal may not have necessarily come up with all that wording. So hence the mistake may have crept in. We may not have applied our minds to that properly and exactly how that read, but our intention, I'm clear that that was our intention. So it might have been drafted by someone in the technical team.
Well, Mr. Besser, can I suggest to you that that's confirmed by what you record on the next page, page 99, because under the conditions, you'll see at paragraph 6, you set out, in effect, a summary of what I understand your evidence to be today. At B, you say, the coal proposed to be supplied from, namely Brakfontein and Brakfontein Colliery Extension, must comply with Eskom's technical requirements and Eskom's coal supply requirements, including but not limited to Eskom's full combustion test. For the avoidance of any doubt, if these requirements do not render compliance for supply to Eskom's Majuba power station, Eskom shall outright reject the proposal and no coal supply agreement shall be entered into. That is quite a position to be taking up in relation to this coal supply. Why did you think this condition was necessary?
At the time, there wasn't yet a full combustion test for the blend, and that's critical. I think it's quite clear from some of the earlier technical reports that, and even from my own knowledge, and other people may support this, is that seam 4 lower is generally acceptable across Mpumalanga. Where the qualities go high, there are suppliers that do blend in the seam upper. Whether Eskom always agrees to that is another matter. Sometimes Eskom's not knowledgeable about that, but here specifically, they wanted to contract for seam upper and for seam 4 lower. So it is very important that we were very clear into what the blend should be. Very difficult to police, other than proper stockpile certification, as Dan and Mashigo and Mr. Opperman indicated. But here, because they specifically they were pushing very hard to supply the 4 upper and the 4 lower seam, and a blend of that. Our technical team wouldn't sign off on it. They wouldn't be expected to sign off on it, and they wouldn't take it to the power station manager to sign off on it, unless they were satisfied that that coal met Eskom's requirements. And I needed to protect against that.
Thank you. Your letter was then forwarded to Tegeta. You weren't copied on this set of emails, but I would like to draw your attention to them. Chair, these are emails that have previously been disclosed through the Gupta leaks, and we have copies of them from the hard drive. There will be other emails that have not yet previously been disclosed, but this is one that has. If you go in file 4 to page 789, you will see that Ms. Nchanga forwarded this letter of yours to Mr. Nash and Mr. Mudliar and copied you, and I take that from the bottom of page 789. Mr. Besser, do you have that?
Yes, I'm not very. I've read it before once somewhere. Yes, again, it surprises me. This Eskom shall. The grammar's wrong, but I guess Eskom shall have the option to enter into an offtake agreement, and it's clear that he was not happy.
We'll go to that in a moment. Let's just orientate ourselves in the email, if we may. The email that appears at the bottom of page 789. Who is that from?
Are you asking me this? It appears to be from Ravindra.
No, below that is another email that begins original message, sort of three-quarters of the way down the page.
Yes, so 3/4 down, Ms. Ayanda and Changa sends an email to
Mr. Nath.
Oh yes, it's underneath. To Ravindra Nath, yes. He would have, I think he was the CEO or general manager for Tegeta.
And as the email reads, "Good day, please find attached letter for your consideration. Should you wish to discuss or collect the original, please advise accordingly." And I can confirm for you what was attached to that email, although we didn't duplicate it in the file, is your letter of the 12th of February.
And I see I've been copied though.
And you were copied on the sending out of the letter.
Yes.
But you weren't copied on what is then reflected in the middle of that page, which is Mr. Nath's email to Mr. Essa, copying Mr. Tony Gupta, which occurred at 26 minutes past 3 on that afternoon of the 12th of February. And will you please read into the record what Mr. Nath says to Mr. Gupta in that email?
Dear Tony G, the letter from Eskom enclosed. I'm not very happy with the wording. Eskom shall, and I assume he meant have, an option to enter into an offtake agreement for the additional coal. Further, option to extend for further 5 years. And there he quotes text that I used. It's in inverted commas, option to extend. This shows that there is no commitment on the part of Eskom. Regards, R. Nath.
Right. And that is then followed with an email later that day, which appears at the top of the page between Mr. Nath and Mr. Tony Gupta. And as I read that, Mr. Nath is making recommendations for a response to the letter. Is that as you understand that email?
Page 791.
Well, 789 still has a later email at the very top of it. Which,
yes, there's a response.
Where certain recommendations are being made for a response to your letter of the 12th of February. And where that all ends up, because it's difficult to navigate through these emails, so to be of assistance, if you go to 793, you will see what Mr. Nath sends back to Ms. Nchanga after an engagement between him and Mr. Gupta about how they should be responding to this lack of commitment on the part of Eskom. Because as he read your letter, you were not willing to commit to 10 years, you were only willing to commit to an option for the second 5 years. You will see Mr. Nath's response to Ms. Nchanga at the bottom of page 793. Can you please record there what is said to Ms. Nchanga? You can read the text from "Kindly recollect our discussions."
I'm referring to kindly refer to your letter.
Yes, that's fine.
Kindly refer to your letter reference 722983 dated 12 February. Kindly recollect our discussions in which I mentioned that we want 10 years contract to satisfy our funders, as the loan period is going to be more than 7 years. Further, I explained you that in the initial 5 years or so, we would be supplying 65,000 tons from Brakfontein Colliery, and the remaining coal will come from Brakfontein Extension Colliery. And afterwards, once the resources of Brakfontein Colliery have been depleted, the whole 100,000 would be supplied from Brakfontein Extension Colliery. If we have two different contracts, then this purpose would not be solved. In the light of these facts, or for the sustainability of the mines, we request that you kindly consider the following changes favorably.
Thank you. And then we don't need to go into the drafting suggestions that are made. The upshot is that they wanted a 10-year commitment from Eskom for proposed volumes of 65,000 tons initially to be increased to 100,000 tonnes from October 2015. Mr. Bester, is that what was eventually contracted for?
I recollect that that we did contract for 100,000 tonnes from later on in the contract. It was probably October, and the price was the same, and that most of that would probably come from Fontaine extension.
And you did not retain the option for the 5 years. You committed to the 10-year agreement.
Correct. The CSA was signed for 10 years. Yes.
Why did you make that change?
It probably seemed reasonable to me at the time. But again, I think the contract was clear that the Fontaine extension still needed to undergo a proper burn test.
Well, let's just probe that a bit further. The reason offered for wanting the 10 years was that Tegeta needed to satisfy its funders. Why would that have been a concern to Eskom?
For Tegeta, but not having engaged with them, I would assuming that that they were engaging with funders, it would make sense to me that it would be more sustainable and more justifiable for a lender to lend you money for a longer period. It would make more sense.
But did you interrogate the issue?
No.
Why not?
Because it probably seemed reasonable at the time.
I'm not sure why that would be so, because a day earlier you had resolved to only commit Eskom to an option for the second 5 years. So what happened between the 12th and the 13th that made a commitment for 10 years more reasonable or appropriate?
So, because they hadn't specifically insisted on 10 years, I still preferred it to be an option. I mean, it's always better to have an option than have a commitment.
Indeed, but then why contract for the commitment?
Because if it made sense and there was a requirement, then there shouldn't be an issue with committing for a longer term contract.
Well, I think Ms. Hofmeyer is trying to understand the change of attitude on your part to the request for the contract to be for 10 years as opposed to 5 years. Initially, your attitude, as I understand the position, was that it should be for 5 years with an option, if I understand correctly. But later on you agreed to 10 years. And she says the reason why they wanted the contract to be for 10 years, they told you why. They wanted to satisfy their funders. But from Eskom's point of view, why was it better to have a contract of 5 years, the one day, and then later it changed to be better to have a contract for 10 years?
When they initially offered the coal, they offered it for 5 years, Chair. So when they requested that they wanted to supply us additional coal, the best negotiating position for me was to say, yes, that's fine. If we do need it, we will take it. But yes, they clearly changed it and they wanted the contract for 10 years. But in my mind, and I can't reflect specifically the conversation I had, but even sitting here today in hindsight, there shouldn't be any reason if the coal complies to the specification and if Eskom has the requirement. So I cannot recall if there was specific what the specific conversation was. I do recall now that I've read it again that there may have been a discussion around them being securing funding. It still doesn't seem unreasonable to me.
Well, in terms of Eskom's needs for coal as at that time, and with whatever projections into the future, Eskom may have made. Was it better from that point of view to have a longer term contract, as long as the supplier was a credible and acceptable supplier?
Chair, correct, yes. But if I was able to keep the position I had earlier and they hadn't picked up on it, clearly, if it's at Eskom's election, that would probably still have been the best option for us to be able to call on that coal when we needed it, and not to. Then it's still an option. If we want the coal, it's there, and we can require them to supply it.
So it's better to have an option rather than an obligation.
It would always. It just stands to reason that it would always be better to have an option.
Because I think that's where Ms. Hofmeyer is. That's the point on which she is on, to say it makes sense if you say, for now, we'll contract for 5 years, but we'll include an option so that it will be up to us to extend by another 5 years. So in other words, when the time comes, you as Eskom can look at your requirements and look at the whole situation, and if at that time it is in the best interest of Eskom to extend, then you have the option and the right to extend. But if at that time you look at the whole situation and you conclude that it would not be in the best interest of Eskom to extend the period with that supplier, then you decide not to extend. But if you commit yourself as Eskom to 10 years, in other words, you don't go for an option to extend, you have already committed yourself for 10 years. And logically, one thinks it's better to have an option rather than to have a commitment, as you said earlier on. But you seem to think, well, maybe there wasn't much wrong with having a commitment. Maybe from the point of view of the needs of Eskom, maybe the distinction between having an option and having a commitment in that context maybe was not too big.
Chair, maybe if I can put it a different way, I don't think it's necessarily, if there's a requirement for Mijuba and we can show that there is a requirement, I think at the time there was still maybe 400,000 tons of coal. There was the shortfall for the remaining period of that year. We had identified another requirement for an additional amount of over 1 million tons of coal for the subsequent year, and that requirement increased further. So it did correspond with the supply plan that we got from management. So in itself, if you were comfortable with the supply, if you're happy with the supply and the coal and the price and the quality, and the supply could meet that, in itself there's nothing wrong with it. But as a negotiator, as an experienced negotiator, yes, if I could negotiate a position where Eskom has a right at its own election, yes, that is a better position to have, but that's a negotiated position. So even though these are letters and we're not negotiating face to face, it's a negotiated position. And in itself, again, even as I sit here today in hindsight, there wouldn't have been any good reason not to contract for a longer period. And again, that's probably why we made absolutely sure. I mean, if I recall, I don't think the additional coal had been properly signed off in terms of its qualities.
Mr. Best, I'd like to follow up on that last statement you made, that there was no good reason not to contract for the longer period. I want to suggest to you that there were two good reasons not to contract for the longer period. The first of those is that at February 2015, no financial assessment had yet been done of Tegeta. Is that not correct?
I'm not aware that one has been done. I've been shown, yes, that it's been done. I've been shown a report that was done subsequent to that, yes.
But you weren't aware in February 2015 of the financial position, Because that report was only done at the end of April 2015. Is that not correct?
I would probably have seen their financial statements when they were available out of interest.
So just to be clear to us, did you consider the financial position before committing Eskom to the 10 years?
I may have, but it's not my call.
Are you aware that the financial assessment that was done did not recommend contracting with Tegeta for the Brakfontein CSA?
I am aware that that was the conclusion, yes.
So that would have differed from the ad hoc conclusion you made in February 2015.
So it's not for me to have reached a conclusion or to advise that the contract can be entered into on that basis, no.
Right. So I said I'd give you two reasons why it wouldn't have made sense at the time to contract for 10 years. The first was that either the financial position was not known, or if it was known, any view formed at that stage that it made sense to contract with Tegeta would have been contradicted by the later view of the financial department, which said the contract shouldn't go ahead. That was the first. The second is that there were two mining rights relevant to the Brakfontein Colliery and the Brakfontein Colliery extension. Are you aware of that?
Not specifically, but I have been told about that.
Okay, they are referred to in the coal supply agreement. I would like to deal with them briefly, Chair, particularly because it's an aspect of the National Treasury report, which in fact appears on our investigations to be incorrect. But it is relevant to this point about the reasonableness of the 10-year contract. So if we could go to those mining rights, they appear in file 4. The first of them is at page 749. And the second of them, just for your reference, is at 774. I'm mindful of the time, Chair, and so I would like to deal with this fairly swiftly.
Yeah.
The first mining right at 749 is a mining right that was granted in 2010 and would expire in 2020. In other words, expire after the first 5 years of the contract if you were concluding it in 2015. Do you accept that?
Yeah, maybe you should repeat that. I'm not specifically looking at it. So the mining right was granted in 2010, and it would have expired?
Let's go to 754, in fairness. This is a mining right for the colliery, not the extension.
Right.
And you will see in clause 3.1 on page 754, it says this mining right shall commence on the 26th of October 2010 and will be enforced for a period of 10 years ending on the 25th of October 2020.
Right.
That was the reference I made. So it's a 10-year duration that's going to expire after the first 5 years of the contract, which was going to be entered into in 2015. Do you see that?
I do see that.
Right. The second mining right, which you will find at page 774, related to the Brakfontein extension. Remember, the extension is not even being mined in March or February 2015. That was the evidence of Mr. Opperman at the moment. And yet the CSA was concluded both for the colliery and for the extension. The colliery had a mining right attached to it for 5 years, until 2020. The extension, you will see, would go on beyond that, because at page 779, this mining right, at clause 3.1, would commence on the 6th of March 2014 and run for a period of 10 years ending the 5th of March 2024. I suggested to you that there was a second good reason to maintain an option in relation to the second 5 years rather than committing to a 10-year agreement for Eskom. And I said that one of those reasons might have lain in these mining rights, because there was only a mining right for the first 5 years in respect of the colliery that was being mined at the time and in respect of which combustion tests could be done. But there was no mining right beyond the first 5 years for that source of coal that was being mined.
Correct.
The extension was the only thing that could take you beyond 5 years in terms of the mining right, but it had not been mined and no coal had been tested from it yet. So wasn't it sensible and prudent in the context of these mining rights to keep the agreement to 5 years plus an option for 5 years? Because you didn't know what you would be getting from the extension.
Correct, it would be more prudent.
And nonetheless, a 10-year agreement was concluded.
Correct.
Thank you.
At the time, you agreed to a 10-year contract. Had you satisfied yourself that this was the position, namely, in respect of the extension, there was no mining operation taking place as yet. In respect of the colliery, although there was an operation going on, the mining right was for a much more limited time than the 10 years.
Chair, I was not specifically aware of those timelines. There's a cross-functional team that checks these matters. I wouldn't have specifically applied myself to the.
Yes. So,
to the mining
so you
rights.
would have relied on them having done their job.
I would have relied partly on legal but mainly on the technical team. The technical team would have applied their minds to this.
But would they have, would you not have had to see documents emanating from whatever team to say this has been ticked, this is okay, or did they have, or was the position that you didn't have to look at that, the mere fact that the contract came to your level meant that everybody who had to deal with anything prior to the contract coming to you was satisfied, and therefore you could make your own decision on the understanding that everyone else had no problem, had checked what needed to be checked?
Chair, I think the way that it's structured is, yes, there's a number of cross-functional teams, and at the end of the day, we all report to the divisional executive. So my function is very clear, and I think it's set out very clearly. If we go to that, the memo I wrote to Mr. Mboweni on the 10th, under advice from the legal team member, advised me to be very careful about what I had negotiated, what I had concluded, and to apply myself to my part of the business, which is negotiating for a certain price, a certain volume, and a certain time. The qualities included in the report are provided by the technical team. We referred earlier to a checklist. That checklist would have been signed off by somebody. I wouldn't myself have looked at the mining right, and that recommendation and that checklist would have gone to the divisional executive, who has the signing authority to conclude. So I wrote him a memo on the 10th of March, the day that he signed the contract, to say that I've done this and this and this, and there should have been by that time, he should have been supplied with a full checklist with all the supporting documents, if he so required it, and the sign-off from the various departmental managers.
Okay, thank you.
I do want to go to that briefing note, but there are aspects of your statement that we need to deal with in advance of it, because you deal in your statement with the requirement that Mr. Mboweni placed on you to conclude this agreement within 48 hours. And I'd like to take you there in your statement. If you go to page 13 in file 3, Chair, just before we go there, I recall I must just conclude the point on the National Treasury report. I indicated that there was an error in relation to it, and it relates to the mining rights. What National Treasury found, and I'll give you the reference, Chair, I don't suggest we go there right now. Their report is in the 5th file, and you'll find the reference at page 1098 at paragraph 6.3. National Treasury, when it looked at this agreement, had clearly only seen the first mining right. And so National Treasury's conclusion was that this entire agreement was irregular because it was a 10-year supply agreement in respect of a mining resource for which there was only a license for 5 of the 10 years.
Yes.
We have subsequently found the second mining right through our engagements with Eskom. But as we've traversed previously, the second mining right was in respect of the extension that had not yet been mined, and in respect of which the suitability of the coal had not yet been determined.
Yes.
But Mr. Best, I'd like to go back to page 13, because here you start to talk about significant pressure and focus starting in 2015. And this is also where you refer to some of the evidence you gave earlier about your awareness that Ms. Nteta was being engaged directly by Mr. Koko, although she reported to you. And you say in the 5th line, Mr. Koko never directly put pressure on me, but he did put pressure on her. That's a reference to Ms. Nteta. And then you go on to say, Mr. Vusi Mboweni at one stage instructed me to finish off the commercial pricing negotiations before the end of the week, and a number of weeks later he told me to get the agreements ready to sign within 48 hours, or he would find someone else to do it.
Apologies, can you just make sure we're on the same page? I'm aware of the interaction and the discussion, but I'd like to follow. I'm on page 13.
Yes, at paragraph 30 of your statement.
Okay.
So it's in the middle of the paragraph that I was reading there, that Mr. Mboweni both instructed you to finish off commercial pricing negotiations before the end of the week, and then a number of weeks later he told you to get the agreements ready to sign within 48 hours, or he would find someone else to do it. What did you understand that to mean?
That he would replace me with someone that he was comfortable to do what he wanted. The other thing that's important there is I told him that I might not have said it specifically, but I do refer to the fact that these are lengthy contract agreements, so we cannot even expect our counterparty, since us agreeing to those terms on the 30th of January, we would not expect to sign a contract within even 3 months with a supplier that is not experienced with our contracts. It would have been probably the first time they've seen it. The coal supply agreement on its own is plus 60 pages. Then there's several annexures which I myself don't even know to the back of my hand, because it's very technical. It refers to sampling procedures, transportation, invoicing, and it's very important that you engage. So for both parties, I said to him, I try to indicate to him that he's rushing this and his expectations are unfair. And it doesn't surprise me that that things didn't. If you read the agreement, you'll see there's several mistakes even in that.
So you must have taken the view that you were not acting as quickly as he expected you to do in concluding the agreement. Is that right?
Chair, my expectation is that even though in his own mind he may have not thought that, I think he was under pressure, and he may have been told that I needed to do it. It's not in the evidence, but I subsequently read in the publication that, or it was in a statement. I think in the draft Fundutsi report, he does say that the chairman had told him that he should run the negotiations himself and get it done. I wasn't aware of that, obviously, at the time, but I was really surprised. We were making progress, and as I said to you again, as I said earlier, with incorrect pressure being applied, it's likely that people don't apply their minds properly. It's not surprising that maybe the technical team, and I'm not sure, I didn't engage with him myself directly, whether they knew that this was the case or whether they didn't know, whether they got pressure from Mr. Mboweni or even from Nteta. I didn't engage with him directly on this matter.
So are you suggesting that when he put pressure on you the way he did, saying you must conclude or sign the agreement or have the agreement concluded within 48 hours, otherwise he would find somebody else, are you suggesting that you didn't necessarily think that that came from him as such, that you didn't necessarily think that he thought you were too slow, but you thought it could be that it was just because of pressure from above him, pressure on him that came from above him?
Absolutely, Chair. At the time, I had no doubt that the pressure was coming from above. I always assumed that Mr. Mboweni probably wasn't yet comfortable with the role he was in.
Okay, and at that stage, whatever pace the negotiations were taking, you were not reluctant to conclude them. You were just wanting to make sure that everything was done properly in terms of not making mistakes in terms of the contract. Or were you reluctant to, at that stage, to have this contract concluded?
Chair, the part of my functionality I articulated quite clearly. There were two areas that concerned me. I wasn't aware of the mining rights, so I didn't raise that. And it was one of them in particular, as has come across quite regularly, is that the burn test hadn't yet been completed to agree to a blend. And I think the other one was that I knew that we, and just from my team's interactions with the supply development team, that's one of the things that my department took care of. We would engage with, because we were the liaison between supply development and the supplier. It was very seldom that supply development engaged directly with our suppliers. Most of the other functional groups, because of the complexity of the understanding, technical team would interact directly with Tegeta, the transport team, when it became appropriate to the handover, and they would have engaged directly. They would have gone to site, they would have seen what sort of way bridges there are, etc. And all of their findings would have been incorporated. Everything normally worked very well if everybody had the time to go to site, check what was there, etc. So there were two aspects I highlighted. That is that we hadn't had sign-off from supply development. Supply development wanted us to I think it was either to force to get it to be at 50+1 already, or to have that agreement. I think I've seen some correspondence that will help me. That they were at the end of the day, they were happy that an agreement had been reached that they would achieve the 50+1 by 2018, but that wasn't finalized yet. So I highlighted that in my note to Mr. Mboweni, but I didn't highlight the financial position to him. The finance department, and then I have I have my own view on the sustainability of the contract, which is why I probably didn't highlight it as a risk. Yes, even from the financials, and I can't say that was my recollection, or whether it's because I've looked at them recently. But it's clear that they made losses in the first 2 years. But in my experience, that wouldn't have surprised me, because it was a mine that was not yet supplying sustainable volumes to anybody. They had tried, clearly, and when you're developing a mine, it's not surprising that you sustain losses during your ramp-up period. So I wouldn't have highlighted that specifically. And also, it sounds like I'm protecting myself, but I was not the functionary reporting that part to Mr. Mboweni. Finance did not report to me. Finance, in fact, did not report to Mr. Mboweni either. They reported, as Snell indicated, to a direct line report. However, some organizations refer to it as a dotted line reporting. So they were a support function to Mr. Mboweni, so they would have given him that report. It's unfortunate that that report wasn't given to him timelessly, but I would have, had he raised the report to me, I would have probably have told him that it's likely that with the contract of this magnitude and this volume and the fair price, and it's still my belief that we negotiated a fair price, that they should be sustainable. And then the other matter, the one that I particularly knew wasn't finalized, was the coal qualities. It's really not my responsibility, but the coal qualities wasn't signed off by the technical team. So we had to, I had to caveat that.
Okay, no, that's fine.
Mr. Best, I've just been informed from the transcribers. Would you mind just speaking a little bit further back?
Sorry.
In fact, no, usually we have to ask witnesses to go closer to the microphone, so this is a rare occasion where there's some interference just because of your proximity to the mic.
Otherwise, if there's still space, you can move the mic a little bit away from you. That's another way of doing it. Yeah, okay.
Mr. Bester, you've spoken a bit in your most recent reflections for the chair about the role of the financial assessment. You made it clear earlier in your evidence that that's not your responsibility, it's not your domain. Is that correct?
Correct.
And but were you aware at the time that you did your briefing note for Mr. Mboweni that a financial assessment had not yet been done by those who were responsible for doing it?
No, I wasn't aware of that.
So tell me how that would factor in, though, because you were given a 48-hour ultimatum to conclude this agreement. Would it not be part of your briefing to him to identify, I haven't seen a financial assessment yet, amongst other things, or is that not how it works?
No, that's not how we, when we were reporting to Kiran Maharaj, all the functionaries reported directly to her.
So what is the purpose of your briefing note of the 10th of March then? Let's go to it so you can have it in front of you. It's at file 4, page 796. So let's just orientate ourselves. We know you got a 48-hour ultimatum to conclude the drafting of the contract. We also know that the contract was signed on the 10th of March 2015 by Mr. Mboweni. So what role does this briefing note play in relation to that period?
It is unusual. Whether I came up with that idea myself or whether I was advised by my legal counsel at the time, I can't recall. But we felt it best to set out what I had, or what my department had agreed to, and what had not been agreed to in my mind. So yes, it was to cover myself, and to brief Mr. Mboweni on the high-level terms and conditions. So I guess it had two reasons, but I cannot deny that it was partly to cover me.
But it didn't flag the absence of a financial assessment. Is that because in the course of the 10th of March you assumed he would go looking for that before signing the agreement?
I assumed he should get that control sheet, and he would have. No, but it's not on the control sheet. As I said, in hindsight, he may not have been aware to check for that. And yes, I was not aware that it wasn't available. It should have been available, and in the normal course of business, it would have been available timeously. I was surprised. I actually don't have a copy of it. It's not in the list of documents I had seen. So I was actually surprised to see that it was done in April.
Right.
Is that, on that briefing note, paragraph 1B, is that a reference to Fontaine Colliery in the last line correct, or should it be Fontaine Colliery extension there? Where it says the proposed volume is commencing at 65,000 per month from 1 April 2015, increasing to 100,000 per month from 1 October 2015, when coal from Fontaine Colliery is available and the contract conditions have been met. Do you understand the question?
Yes, you read that correctly. So in hindsight, I should have referred to the Fontaine extension as well, but it is referred to later on again.
Yes, no, I just mentioned because I think when Mr. Opperman was giving evidence at some stage, I wasn't sure how the distinction was made between Fontaine Colliery and the extension. And in terms of the contract, as Ms. Hofmeyer pointed out, I think then if you look at the contract, they use extension as part of the name. But it's clear from that memo, I think from paragraph 1A, that you make this distinction between Fontaine Colliery and Fontaine Colliery extension. But when I read B, it seemed to me that it wouldn't make sense unless you intended extension. But I think you are confirming that you intended extension in B.
Correct. It should have been there if it referred to the higher volume.
Okay. I think I'm going to just amend it so that at least for me it's clear when I read it some other time in the future that it's the extension that you intended. Okay, thank you.
Chair, if it assists, even the line above refers to both. It's maybe an oversight not for us to have included it again. In A.
In A, you have Fontaine Colliery and Fontaine Colliery extension. Can you see that?
Yes, Chair.
Are you saying that there should be some amendment there as well?
No, Chair. I'm saying we should have repeated that similarly, probably in the next paragraph in B. Correct.
Yeah. Thank you.
I'd then like to deal with the reference you did make in this memo to the need for the successful combustion test, because that is the second suspensive condition that you refer to right at the bottom of the page, where you say at B there under 2, prior to acceptance of the supplier coal for both Fontaine and Fontaine extension, the supplier must meet Eskom's environmental and technical requirements, which include but not limited to a full combustion test. Mr. Bester, I dealt with Mr. Opperman on this morning. You're aware that that was included as a condition precedent in the agreement. And we reflected this morning on its odd arrangement in the coal supply agreement because it actually is a duplicate clause 10. Is it fair to conclude that that's a product of the speed at which that contract had to be put together?
Yes, Chair. And the fact that when you may recall, Ms. Hofmeyer, that when you brought that to my attention previously, I hadn't recalled it. So it's a clause that I had forgotten about. And it is a clause that I must give credit to our legal representative on the team would have built in. I'm not sure I can't remember at the time. I even would have phoned her and I would have said, I need this and this and this. And she would have assured me that she's put certain protections into the agreement. Specifically, I cannot recall having actually read it. I think I would have picked up that there was a wrong pagination.
Well, it's one thing to include it in the agreement. It's another thing to make sure it gets
Correct.
implemented.
Correct.
Now, this agreement was signed on the 10th of March. The agreement would not have become operative, according to that clause,
Correct.
unless a successful combustion test was done by 4 p.m. on the 31st of March. After the contract was signed, who was going to check that?
Yes, that's an important clause. So, I mean, in hindsight, I should have kept my eye on that. So, the normal course of procedure is for once a contract is concluded, for there to be a handover, as Gert. So, the team that would have negotiated that, so that would have been Ms. Ayanda and Ted, should have sat with Gert Opperman. And there would have been some of the other functionaries probably present as well. There should have been someone from technical, and there should have been someone from who'd engaged with the logistics part of the contract. And they should have conveyed to Gert specifically any deviations from the norm in that. And it's my understanding that probably wasn't done timeously, and nor was that done to that level of detail, because he seems to be unaware of that.
Well, the challenge that we face in the implementation of this contract is that it appears no one checked whether on the 31st of March that condition precedent was met. Was anyone asked not to check?
I'm not aware that nobody was asked not to check.
But you accept that you ought to have kept your eye on this aspect?
That would have been an important aspect. It may have been that my understanding and what was captured, because I reflect that I wrote another note to Mr. Mboweni on the 4th of April. I'm not sure whether you have that. I only have an electronic copy of that. I wrote him a note, and at the time, the reason I wrote him the note was that I had been alerted to the fact that the Sunday Times and the Mail and Guardian were going to run an article on the agreement that had been concluded. I wrote to him to bring him up to speed, and I said to him that as far as I'm aware, the burn test, and as far as I was aware, that coal, from what I could establish, the coal supply had not yet been commenced with, and that the burn test, which should have specified the ratio between which SIM4 upper and SIM4 lower would be supplied, had not been completed. So it's clear that I did not highlight the 31st of March issue to Mr. Mboweni.
The contract didn't come into existence because that condition precedent wasn't satisfied. But I'm not aware of this memo. But was that not something you should have brought to his attention on the 4th of April?
Had it been in the top of my mind, I should have brought it to his attention. Yes, that's a material matter, yes.
Thank you. Mr. Best, I'd then like to move to an amendment to this agreement that occurred shortly after it. That is an amendment on the 12th of May 2015. I'll find you a reference to it in a moment. If you go in file 4 to page 804, can you tell us what that document is?
It amends the coal quality specification. Without comparing it to the contract, I can go on memory, and from my recollection, we may have tightened up one or two of the
I think that's fair. That was the evidence of Mr. Mashiko. But what I'm interested in is the omission of the 2 asterisks that appeared both when you first wrote to Tegeta about this agreement on the 12th of February, which was then included in the coal supply agreement that was concluded on the 10th of March 2015,
Right.
and which the evidence before this commission has been it was a further protection for Eskom because it required a full combustion test to be done on all proposed coal. But now this section of the agreement is amended to remove those two asterisks. Do you see that? Because, and it might be useful just to compare it to the coal supply agreement, because the
I'm
coal
sorry, are you at 804
Yes.
or
And
804?
804, Chair, is a letter, but it's a letter amending the coal supply agreement.
Okay, well, I see that I am at 804.4.
Oh,
So these point something are causing some confusion.
they're dreadful.
Yes, I am at 804 now.
Now, in this letter, Mr. Bester, you've confirmed that you amend the quality spec of the coal supply agreement. And just so that we can compare it to the quality spec in the agreement, you can also have reference to page 890 of that file, because that's the clause within the CSA that was concluded on the 10th of March. And what I want to ask is why those two asterisks under the quality spec table at page 890, which specified that full combustion tests would be conducted on all proposed coal prior to delivery and acceptance by Eskom, was then removed when this provision was amended on the 12th of May.
So I don't recall the instance specifically, so applying my mind to that, it could be that the intention is only to replace the table, and that, so if had it been appended as a proper amendment, I guess that would be the fuller answer. Had it been properly amended, it should be an amendment signed by both parties, but the legal team are normally quite specific in this, and they say that this replaces that specific. So in hindsight, there may not have been a specific intention to remove that clause, because if you simply replace the quality table, maybe there was no intention of doing that. But I can't say that was the intention, because I don't recall the specific instance.
But at least I understand you to be saying you don't recall specifically wanting to remove it or intending to remove it with the amendment on the 12th of May.
Correct, but I would assume that the amendment wouldn't necessarily be removed either. I would hope not.
Thank you.
Well, the first paragraph at 804 says you are amending, you say in that paragraph, you are amending the contract specification as indicated below. And you say the coal supplied from the Fontaine colliery shall comply with the specification below. I think the two asterisks that Ms. Hoffman is referring to at 890, do they not relate to something that needed to be done even before you get to the specifications, or not really?
Chair, not really.
Not really.
If you note as well, the line underneath that refers to the hard grove index,
Yeah.
there appears to be a change there as well. In the contract, it refers to there's a less than 55, where the single asterisk is, and I see that's replaced with a greater than 50. I think the sign is incorrect, but the The entire table on its own and that reference to the Hardgrove Index are quality specification. The double asterisks is, I would say that it could be argued that it was not the intention to replace that, but merely to replace the table and the specifications as they relate to the power station's requirement, and that the burn test would still be a requirement. But again, I'm trying to apply my mind in hindsight. I do not recall specifically the discussion here, but I would argue that there should not be an intention to replace that.
Well, I didn't realize, but I see now that the single asterisk that we find at 804 is or appears to be the same single asterisk that we find at 890, which means that anyone would be entitled to say, if you meant to, in 804, to just deal with the specifications in terms of quality, why include the single asterisk but not the double asterisk unless you intended no longer to, unless you intended to exclude the double asterisk. So it creates that impression. Anyone who puts the two documents together and understands that the one is an amendment of the other would see that one of the things that's not there in the one is the condition relating to the two asterisks, and it's not there in the other one, and then there may be room for somebody to infer that it was no longer the intention that it should continue to apply.
Chair, I would say that that could be a fair conclusion.
Yes. Yes. Okay.
Mr. Besa, just jumping ahead a bit, want to underscore the significance of that. We heard evidence from Mr. Opperman that that clause would have had a particular relevance in relation to the extension, because it would have been the protection for Eskom that as and when that extension became available as a source, there would be a contractual requirement that a full combustion test be done and it be successful. So it is a clause, I would suggest to you, of some importance in protecting Eskom under this agreement. Do you accept that?
I do accept that, yes. And that would be the intention.
It would be the intention, and as the Chair has indicated to you, the concern is then that it goes on the 12th of May and is no longer a protection for Eskom in relation to coal supplied from the extension. Do you accept that?
I do accept that, but this is not yet the contract to be amended. It's an agreement to amend the contract. It should have been a proper amendment to the contract.
Was it ever properly amended?
Not that I'm aware of. I haven't seen any other documentation with another annexure, no.
But were these revised quality specifications the ones that were applied?
We would have to check that with the operations manager.
Chair, I do see that we are past 4 o'clock. We are at 4:15. I have 3 more topics to deal with Mr. Bester. I can continue now. Alternatively, we could do it in the morning. I just am concerned about the sort of seepage into the rest of the days of our evidence and the impact that it's going to have potentially on other witnesses, but we're entirely in your hands on that.
Well, I think Mr. Maleka, or was it you or both of you, asked for an arrangement last week in terms of which we would finish at 4:30 instead of 4 o'clock, so I'm happy that we continue until 4:30 at least, yeah.
Thank you, Chair.
Okay.
Mr. Besser, we've dealt with that amendment in May 2015. I would then like to take you to a series of interactions between Tegeta and Eskom that occurred in June 2015. Because in June 2015, Tegeta approaches Eskom a few months into this supply agreement to start providing more coal than that which was contracted for. And you will pick that up at page 808 of file 4, which is the one we've been dealing with. As I have it, this engagement starts on the 19th of June, 2015. Can you tell us what that document is at page 808?
It really, in summary, refers in the letter to get are offering additional coal to Eskom, and to, if I read it correctly, to increase their supply to 200,000 tons. It could actually read it that they would supply an additional 200,000 tons, I guess.
And they say they want to do that from the month of October 2015. Is that correct?
Correct.
Now, as we understand it from the letters we'll look at shortly, there was a meeting held with Tegeta pursuant to this letter. Do you recall that meeting?
No, I don't recall engaging directly with Tegeta other than the 30th of January.
Pursuant to it or prior to it, or are we looking at different letters? I'm looking at the one at 808, which refers to a meeting that had been that had taken place that day.
Apologies, Chair. Thank you.
So,
I'm referring to one that was held on the same day as this letter, so the 19th of June. And the reason why I say there was a meeting, yes, so they start off, we kindly refer to the meeting we had with Eskom today.
Yes, no, I think what I was picking up on is you said that you are referring to a meeting that was held pursuant to this letter, and I was saying pursuant to
or in
prior
advance
to.
of. Indeed, Chair, that is my error. It was prior to, because the first sentence of the letter refers to the meeting had on that day. Mr. Besser, you also wrote to Tegeta after that meeting, and that is a letter that I have it appearing at 810. But just to be clear, you don't recall that meeting, is that right?
I don't recall meeting them again other than on the 30th of January.
Right.
So I assume that I wouldn't have been there. Yeah.
Your letter, just confirm for us at 811, is that a letter that you drafted and signed?
Sorry, 810.
The one starting at 810.
The one starting at 810, and if you go over the page to 811, it appears to be a letter signed by you. Is that correct?
Yes, correct.
Do you recall this letter?
I do recall them offering additional tons. I can't remember exactly when. And I remember maybe answering it that to the extent that we required it. I don't recall the letter specifically, no, but I can look at it again.
That's fine. What I'm interested in is the last sentence of that first paragraph, because the last sentence of that first paragraph says, following our meeting on the 19th of June 2015, Eskom wishes to record some of the material terms the parties agreed on. To the reader, that suggests that you were at that meeting. Is that incorrect?
I don't recall meeting.
But it could have happened.
It could have happened, yes.
Fine.
But if you had not been part of that meeting, is it likely you would say following our meeting? In other words, would you refer to it as our meeting if you had not been part of the meeting?
Chair, it may have been an oversight from me. The language in the letter would have, I often didn't draft my own letters. I was supported by my team, so it's likely that Ayanda would have written it, and it may have been written in the first person, and I may not have picked up the error. I think I don't recall being at a meeting, and I'm not sure there's any minutes to reflect that. But even if I was at the meeting, I don't dispute the fact that I signed the letter.
Is there a possibility that you might not have been at the meeting, but other people were at the meeting who subsequently reported to you, and when you wrote and then you decided to confirm what took place in a meeting that you did not attend, but you referred to it as our meeting? Is that likely?
Absolutely, Chair. To my recollection, I only remember meeting them the one time.
And is that something that used to happen sometimes, where the confirmation of what was agreed to would be provided by someone who was not at the meeting? Is that something that normally happens?
Chair, what was normal is that I used to pen official correspondence under my name.
Not other people in the team, in your team. In other words, even if it was your team members who were present at the meeting, when it came to corresponding with people outside of Eskom, you would write and not them.
Correct, Chair. They would brief me, and I would.
You would write.
And if I was comfortable with the content, I would sign it off.
Okay.
The letter, as I read it, refers to this proposed additional 100,000 tons that was to come from Tegeta, and then it records the material terms that the parties agreed on, and then those terms are set out under points 1, 2, 3, and then over the page. What is recorded in relation to the coal specification for this additional 1,000 tons per month?
It must comply with Eskom's technical requirements and Eskom coal supply requirements, but not limited to Eskom's full combustion test.
So,
including, but not limited to. So there's an expectation that the additional tons, so I would imagine, reading from this, that since they indicated that the coal would come from Fontaine extension, it stands to reason that we would have included this because there wouldn't have been a full combustion test yet.
Indeed. So the proposal is to get 100,000 more tons from October 2015 from a resource that hasn't yet been tested. And so the coal specification is that there must be a full combustion test successfully completed before Eskom takes that coal. Is that a fair summary?
Correct.
And it even goes so far as to say over the page at 811 that Eskom will outright reject the proposal if that is not satisfied. Is that correct?
Correct.
The other thing is that it talks about the volumes under point 2.
Before that, paragraph 1 under coal specification, you make it clear that there should first be a successful completion of a full combustion test. As I recall, doesn't that take us back to those two asterisks that we talked about earlier? And if it does it not then reflect the idea that the amendment to which we referred earlier on was not intended to do away with the two asterisks?
Thank you for that, Chair.
But I just want to confirm with you whether
Yes.
my thinking is correct, whether it supports that proposition. The fact that you were including it here as one of the terms that had been agreed at this meeting of the 19th, that there should be a full, successfully completed combustion test, doesn't mean that indeed the fact that the 2 asterisk provision was not included in that amendment did not mean that it was intended to be done away with.
Chair would support that, but I think it should have still been at the top of everybody's mind that it would be a new resource that had to that at that date not yet been subjected to a full combustion test. My expectation is they probably haven't mined there yet, and there probably wouldn't have been coal available. So yes, I think it supports what I said earlier, that there should have been no intention of doing away with that clause in the original contract.
And to the extent that what you wrote here under 1 coal specification in relation to the combustion test, to the extent that you accurately reflected what both parties agreed upon at the meeting of the 19th of June, it must mean that everybody understood that that requirement continued to apply.
That would be the reason for capturing that, Chair.
Yes, because if the intention had been on the part of, say, for example, Tegeta, if their understanding was that that letter of amendment sought to do away with the condition that had 2 asterisks, then they may have said, no, but that's been done away with, you can't bring it back here, which it seems they didn't say.
Yes, Chair, I think it's clear here that the intention still was to try and uphold that, that combustion test, which had not yet been done.
Okay.
Chair, maybe another interesting point here is that what is interesting, and maybe it's not that relevant, but the Eskom specification will be determined once the full combustion test is successfully completed. I'm not sure what the relevance of including that is. That may have been under technical advisement, that because otherwise we would have normally just said the Mayuba power station specification be required with. Maybe there was an expectation, as Gert had said, that there might be a deviation on the sulfur that we might need to, but I'm speculating. It's just surprising to see it in that way.
Okay, Ms. Hofmeyer, you can take it further if you
Thank you,
want to.
Chair.
Yeah.
I will take it further because this is an important point as this develops, because we will see in due course that Tegeta is not happy with that first paragraph. So that we will wait to see. However, can I just pick up the point with that the Chair raised with you, Mr. Bester, and you confirmed at this point the extension is not mined. We're in June of 2015. That was Mr. Opperman's evidence this morning. So you haven't tested the resource. You don't know whether it's going to be suitable for Majuba. Why would Eskom be agreeing 3 months into this contract to take another 100,000 tons of coal from a colliery that had not yet even been mined, nor the quality of the coal assessed?
Chair, I can only try and speculate that what our intention was at the time, and maybe what my state of mind was at the time, is that, and reading it now, that it's not a contract. It refers to their coal supply offer. However, their letter, if I can refer to that. So in my mind, if I read it now, it's a reflection of, it's a recordal of the meeting. They write it as a coal supply offer, and we acknowledge that offer.
Well, can we just pause on that for a moment? What you record in the last sentence of the first paragraph is, following our meeting on the 19th of June 2015, Eskom wishes to record some of the material terms the parties agreed on. That reads to me not as an acknowledgement, it's a recordal of the material terms the parties agreed on. Should we not read it in that way?
Apologies, can I refer refer to that?
Yes, of course, it's 810.
I think I've messed up the...
You'll see at the last sentence of the first paragraph, just to orientate ourselves, Mr. Betts, I understand you to be saying that this might only have been an acknowledgement of their offer. And I'm querying that because the last sentence of the first paragraph says, following our meeting on the 19th of June, Eskom wishes to record some of the material terms the parties agreed on.
Agree, yes.
So it's not an acknowledgement, it's recording the material terms that were agreed.
Correct, yes.
Thank you. So it's an agreement to take 100,000 more tons a few months later from an extension that has not yet been mined and the coal of which has not yet been assessed. Is that correct?
It's an agreement, yes, that should all those conditions be met, yes.
But why would Eskom be doing that? I'm just struggling to understand why it commits. It's already entered into a CSA agreement a matter of months earlier to take from October 113,000 tons a month from Brakfontein. The extension hasn't even been mined yet. Why would it want to agree to take another 100,000 tons from an unmined resource?
It doesn't... Again, there may have been a requirement, but I seem to recall that we did include a paragraph, and I know it does disappear later, including a requirement for the volume at the relevant power station. We do appear to cover ourselves initially that to the extent that we have a requirement, and I think at the time I may have been trying to push back on agreeing to that and saying, subject to us requiring it at a later stage.
But Mr. Besser, why did you need to be pushing back at this point? What were you pushing back against?
Because it is a new supplier, and for them to be supplying this volume, yes.
But then why not just say no, thank you?
I'm sorry, could you just repeat that answer? Because
it is a new supplier.
The question, just to recap, the question was, what were you pushing against? Why did you have to push back? What were you pushing back against? And then you said because. I just want you to repeat what you said.
To take 200,000 tons a month, I may have needed to satisfy myself that Mayuba needed it. We may have needed to satisfy ourselves that the supplier could actually supply that.
But Mr. Besser, why entertain it at all?
My view is now, and as I said, I don't know what my frame of mind was at the time. My view is that this serves as an acknowledgement from what was discussed and agreed in the meeting, and we do cover ourselves by saying that should we have a requirement. I know it spells it out differently, including a requirement under volumes in paragraph 2. Subject to all the required Eskom approvals, including a requirement for the volumes at the relevant power stations. And then at the end of the letter, on the next page, what I included in there, Eskom shall bear no liability for any costs and liabilities incurred by the supplier on the basis of this offer.
Mr. Bess, I do have a few follow-up questions in relation to that, but I do see that we're past 4:30, Chair. I'm in your hands as to whether we should complete it or resume tomorrow.
I would have liked us to complete. I don't know how much more time you have. I do have a 5 o'clock meeting that I need to attend in chambers, but how long do you think you need to?
We can complete this letter fairly swiftly,
yeah.
But there will be the further letters that follow it that I'll need to traverse tomorrow.
Yes. Well, maybe if we are going to go into tomorrow, we may as well just maybe adjourn till tomorrow. You just make a note of where you stopped, and then we can. Before we take the next witness, how much more time do you think you may need with Mr. Bester?
Chair, this is the last topic before some concluding aspects that I'd like to have his comment on. So I don't envisage more than half an hour.
Oh, okay. So if we start at 9:30 as we intend to, that should be fine.
Indeed, Chair.
Okay. No, that's fine then. Thank you. Mr. Bester will adjourn now. Please come back tomorrow. We'll continue at 9:30 in the morning.
Thank you, Chair.
Okay.
Thank you,
We adjourn for today and we'll resume tomorrow at 9:30. We adjourn.